Hello, hi, good morning. Good morning, everyone. I'm Attorney Salao, and I will be your lecturer for this morning, May 14, 2020. Before we begin the lecture, I would like to thank Rex Bookstore for inviting me to lecture. Thank you also for organizing this event. And I think we all need this well, on my part, to prepare for what's up ahead. And for those of you who are preparing for the bar exams, I think this is also an important trial run. I think we all need to get to be used to this kind of learning modality. So the topic is special commercial law secured transactions, and our discussion will be based on or is based on the 2020 bar exam syllabus. For the main topics, we have Personal Property Securities Act or Republic Act 11057. Then we will also discuss real estate mortgage. Of course, this is part of the civil code. And so with guarantee and surety, and then the letter of credit. Okay. I just would like to lay some groundwork before I begin the actual lecture. First, the context of this lecture is for the bar exams. Okay, so necessarily we will present this subject uh, para makapag-prepare tayo sa examination and not really for practice. Okay, so my task is to give you or discuss the law and the topic. And for those of you who, again, will take the bar exam, your goal is to pick up key terms and phrases for you to be able to come up with um, a responsive, coherent, and concise answers. For those of you who are not yet uh, examinees or those of you who are still student, I suggest that you also take note because the preparation for the bar, of course, happens in the classroom and not after graduation. Okay, so if you will look at the main topics, Personal Property Securities Act, this is something that you need to pay special attention to because I don't think this was discussed in the classroom. So this is not really a review, but I think more of a first view. Okay, later we'll discuss what is this law all about. But I think it's best to start with the basic lessons on credit transaction. Okay, so a transaction is any agreement, any deal, any contract. Okay, and when we say credit transaction, then we are dealing here with something that one will get today and he or she will pay it in the future. Okay, so that's the context or that's the concept of credit transaction. Okay, because of course not all of us are willing to uh, let go of something without expecting anything in return. And to secure that return, a security is given. Okay, so in the context of today's discussion, security is something given, deposited, or serving as a means to ensure the fulfillment or enforcement of an obligation. Okay, so there are two kinds of securities. First is the personal security, and this is when an individual becomes a surety or a guarantor. And another kind of security is property security, and this, as the term implies, there is a property that secures the fulfillment of an obligation, and this is constituted when there's mortgage, pledge, antichrisis, or other agreements. So let us summarize the secured transaction. PPSA, of course, it stands for Personal Property Securities Act. the security type is property, and the collateral given is a personal property. Real estate mortgage, or REM, it's a personal security, and the collateral is, of course, a real property. For guarantees and letter of credit, these are all personal security. Okay. Now, I think it's important for us also to discuss pactum commissorium. Okay, so pactum commissorium, as stated by the Supreme Court in Martires, a stipulation empowering the creditor to appropriate the thing given as guarantee for the fulfillment of the obligation in the event that the obligor fails to live up to his undertakings without further formalities such as foreclosure proceedings and a public sale. Of course, this is not allowed under the Civil Code, and this is also not allowed because there is a public policy consideration for this. Okay, so basically, pactum commissorium is the automatic appropriation of the thing in favor of the creditor. The elements of pactum commissorium: first, there should be a pledge or mortgage wherein the property is pledged or mortgaged by way of security for the payment of the principal obligation. And letter B, there should be a stipulation of an automatic appropriation by the creditor of the thing pledge or mortgage in the event of non-payment. Okay, so again, as law professors, we are always emphasizing key terms, and the key term for this would be automatic appropriation. But we all need to be careful with this. Hindi lahat malagyan ng automatic appropriation would amount to pactum commissorium. Let's discuss this case, Agoncillo versus Javier. In this particular case, there was mortgage, and in that mortgage agreement, there was this stipulation or agreement that in the event of failure to pay the debt in money, there is a stipulation. Okay, there's a stipulation that the debtor or the mortgagor will execute a conveyance agreement to convey the house and lot to the creditor mortgagee. And the Supreme Court said this is perfectly valid. There is no pactum commissorium in this particular case. Okay, so there is this 2009 bar exam question. I will read. Rosario obtained a loan of 100,000 pesos from Jennifer and pledged her diamond ring. The contract signed by the parties stipulated that if Rosario is unable to redeem the ring on due date, she will execute a document in favor of Jennifer, provided that the ring shall automatically be considered full payment of the loan. The question was, the contract valid? Okay, so if you will read the question again, there is this magic word, automatic, and or automatically in this particular case, and maybe there will be some students who would think, so there is this word automatic, hence this is pactum commissorium, and the answer should be no, it's not valid. But then again, we advise our students to be careful with their appreciation of the facts, because if you will read carefully the facts, there's this provision, there's this part wherein it was said that she, or pertaining to Rosario, will execute a document. So it's not really automatic. Okay, so let us give the suggested answer for this. The suggested answer is yes, because the agreement is not pactum commissorium, as there is no automatic appropriation of the lead. Okay, so the standard answer would be 3 paragraph, right? 3 or 4 paragraph rule. The first paragraph, we always emphasize, is the direct answer. The second paragraph is legal basis, and the third paragraph is the application. Okay, but I think the most important, the most critical part of the answer is, of course, the first paragraph. And my suggestion is your first paragraph should always be responsive. So if the question is a yes or no question, then the answer should either be a yes or no, as the case may be. And then in order to make the life of the checker easier, then we are suggesting that you put in the key term, the key concept, the key principle in your first paragraph. And that's the reason why the first paragraph is framed this way, okay? And for your second, third, or even fourth paragraph, it's best to discuss not only the legal basis, but also the factual considerations for your answer. Okay, so normally when we give a bar exam lecture, we emphasize the substance, the law, but in your preparation for the bar exam, I think it's important for you to prepare also on how to answer, the techniques on how to present an intelligent answer, because substance without the form would not be enough um, as a general rule. Okay, so I think there's still time to develop this skill. Yes, this is a skill, and this skill is something that we can learn, and please make use of the time we have to learn this skill. Okay, this lecture is supposed to run only until 12 noon, and because of this, we don't have much time to to give sample questions and answer. Okay, but the Rex would give you a link. I think I was told that the link is in the caption, okay, wherein you can download the full text of the lecture. Okay, because again, because of the time constraint, and because of the topic that we are about to discuss, you need to have a full text so that you can pick up the key terms and phrases, lalong-lalo na dun sa una nating batas na pag-aaralan. And this is the Personal Property Securities Act. Okay, so this particular law was signed into law on August 17, 2018. Good news, okay? Good news muna tayo. Nabawasan ang bar exam syllabus. Wala na siyang pledge at wala na rin siyang chattel mortgage. Okay? So I think that's good news, but not so good news is that nadagdagan ng Personal Property Securities Act. This was not included in the 2019 bar exams because probably the time element, but this is definitely included in the 2020 bar exam syllabus on commercial law. Okay, so ano ibig sabihin nito? We need to learn this particular law kahit hindi siya na-discuss sa ating classroom. Okay? Now, in my preparation for this lecture, this is unusually long. Okay? Kasi nga po yung mga facts na nabanggit ko. Okay? But in all the laws that I've been teaching, pinaka-importante po sa akin yung malaman ng learner yung istorya ng batas na ito. Okay? So just like pledge, just like mortgage, these are also security contract. Okay? A debtor or A, in this particular case, would obtain a loan from B, the creditor, and to secure that loan, security is given. Okay? If the security is a personal property, that ginagawa natin, pledge. Okay? Pledge, ang istorya ng pledge, di ba? Pupunta tayo sa pawn shop, we pledge our thing there, iiwan natin yung property doon, and then kapag ready na tayong tubusin, tutubusin natin. Okay? Chattel mortgage, the same thing. Uutang tayo, and we secure it by means of a personal property. But unlike in pledge, we retain possession of the thing mortgage. Okay? So, in Personal Property Securities Act, ang importante po dito is to secure an obligation, gagamit tayo ng personal property. Okay? Now, the purpose of the law is twofold. Number one, to establish a unified and modern legal framework. And number two, to strengthen secured transactions legal framework. Because after all, that is what law is all about, right? Establishing the legal framework. Okay? Now, for number one, unified and modern legal framework. I think the rationale of the law is that the current law, pledge, chattel mortgage, these are not enough to cover yung modern situation. For example, how can you now pledge livestock? Diba, meron tayong bakahan o babuyan, alam naman natin dalhin lahat yun sa ating creditor. Okay, so because or probably there are other other personal properties. We still consider them personal properties, some intangible, okay? And we need legal frameworks on how to use these intangible properties to secure obligation. This is what PPSA is all about. Okay? Now, this purpose, okay? For this purpose, Section 66 of the law repealed, amended, or modified certain laws. Okay, foremost is the chattel mortgage law, then some portions of the Civil Code, Articles 2085 to 2013. Of course, this pertains to pledge. Article 2127, 2140 to 2141, chattel mortgage. Also, the particular part on classification of credit, preference of credit, these were all modified by PPSA. If you will look at the implementing rules and regulation of the law, it specifies clearly that the laws or these laws were amended or modified or repealed insofar as personal property is concerned. Okay, so kapag yung batas na nabanggit pertains to real estate mortgage, then the law is still valid. Okay, so that's how the law intends to provide a unified legal framework. Now, let's go now to the legal frameworks. Okay, for the legal frameworks, we will talk about creation of a security interest. Okay? Paano ba natin gagawin ito? How do we create security interest? Second is how to perfect it. Okay? And what's the meaning of perfection? What is the implication? What's the ramification of perfecting security interest? Then, determination of priority. In this particular topic, it's possible that one property is used to secure several obligations. At pag nagkaganon, sino ang may preference, then this will answer that, the determination of priority. Then another legal framework is the establishment of a centralized notice registry. We will discuss this registration later. And then enforcement of security interest. Okay, so these are the legal frameworks established by PPSA. Okay? Okay. So let's discuss first security interest. Okay, so this security interest is defined in the law as a property right in collateral that secures payment or other performance of an obligation. Okay, so that's what security is all about, right? To secure the performance of an obligation. But the law says it includes right of a buyer of accounts receivables. Okay, so ano ang binili? Not the property, but accounts receivables. Okay, so di ba negosyo, there are some businesses that obtains account receivables at yung account receivables na yun, pwede nilang ibenta, and that buyer of accounts receivable may also create security interest on that accounts receivable. Okay? And third is lessor under an operating lease for not less than 1 year. Okay? For number 3, ito po yung mga leasing company. There are some companies, there are some businesses that require equipment, heavy equipment. Pero pwede nilang hindi bilhin yung mga equipment na yun. Ginagawa nila, they lease it from a leasing company, and the leasing company is leasing company that purchased or procured those equipment, at yung payment ng mga company nagli-lease sa kanila would answer for the amortization of those heavy equipment. Okay, so this particular law, PPSA, may also be used to secure the performance of the obligation of the lessor of those heavy equipment in our example, and this may be secured using PPSA. Okay, now for sample questions, okay, because this is the first time that this particular law is included in the exam. Siyempre, hindi naman, I don't know, but I think hindi naman malalim ng tanong. Okay, so we can expect some questions dealing with the basics. Okay, so pwede tayong matanong, what are the purposes of PPSA? What are the legal frameworks to secure obligations under this law? What are the legal frameworks? Di ba yung nasagot kanina? Creation, perfection, determination of priority, and what are the transactions secured under PPSA? All right. So these are possible questions, fair questions na we need to be prepared sagutin. Okay? All right. So let's discuss yung framework, and that is creation of security interest. This is section 5 of the law. Security interest shall be created by a security agreement. So basically a contract, an agreement between the parties creating security interest. Okay? Now, there is a proviso here, provided that the security and interest can only be created on the asset which the grantor has a legal right. Okay, sino si grantor? Ito yung debtor that offered the collateral to secure the performance of his obligation. Okay? So, ang sabi dito, the security interest may only be created on asset na merong legal right si grantor. So, in short, hindi pwedeng i-offer ni grantor yung property ng kapitbahay niya. Unless, of course, the kapitbahay would agree and then magiging accommodation party siya. Okay? Now, so what is this security agreement? Okay? Security agreement under Section 6 says that it must be contained in a written contract. Okay? So, written contract. So, I think bumabalik sa atin yung mga principles under contract law, right? There are contracts that are perfected by mere consent. There are contracts perfected by complying with certain formalities. Okay? So, without complying with those formalities, walang kontrata, or the contract was not perfected. Okay? So, if you will be asked what kind of contract is a security agreement, okay? Masasabi ba natin this is perfected by mere consent? Well, by express provision of the law, there must be a written contract signed by the parties. Okay, the law says that it may consist of one or more writings, and if taken together, if it establishes an intent of the party to create security interest, then that is security agreement. So it means hindi siya kailangan isang dokumento lang. Okay? Now, okay. Note, okay, the implementing rules and regulation provides template contracts. Okay? Siyempre, hindi naman tayo ine-expect. No? Hindi naman tayo ine-expect na examiner siguro na write, okay? Or sa legal forms, write a security agreement. But in case lang na meron tayong ganong katinding examiner, the suggestion would be to look at the implementing rules and regulation. It's downloadable sa internet. And if we look at Annex A, it provided a model security agreement, Annex A, para sa specific asset. Okay, so this is how it looks like, security agreement. If you will look at the model, it's a standard contract. Okay, so yung stipulations lang ang ating important basa. Okay? Now, Annex D, a model security agreement covering all assets of the grantor. Okay, so what's the difference? Yung Annex A para sa specific asset, but if the grantor would want to use all of his assets to secure the performance of the obligation, then yung contract provided under Annex B is the model agreement. Okay, so that's how a security agreement is created. What's the extent? Okay, the extent of security interest, of course, yung collateral. Okay? And kung natatanda natin yung rule dun sa chattel mortgage law, right? There is a requirement of affidavit of good faith. And the requirement basically is to be accurate, be precise in the description of the collateral. But under PPSA, the requirement was relaxed. The law says it's sufficient if it reasonably identifies the collateral. Okay? Now, aside from that collateral, okay, kasama din sa security interest yung proceeds. The grantor would sell collateral, then the proceeds of the sale is covered by the security interest. Ito po yung sinasabi nating modernization of the law. Okay? And letter C, the security interest also extends to commingled funds. Okay, so that, let's say, this property was used a collateral, and then it was sold, and then the proceed has been deposited or was deposited in probably in a deposit account, and of course, the funds has been commingled with other funds, then kasama, no, yung security interest would be created on the commingled funds. Okay, under letter D, future property. Okay, future property. Then again, kanina, only when the grantor acquires the rights in it or the power to encumber it. Okay, so natatandaan niyo po yung mga future properties, yung mga, let's say, mango plantation. Yung mga para sa mga estudyante ko, lagi nilang naririnig sa akin yung example na to. Mango plantation, namumulaklak pa lang yung puno, wala pang mamangga. Okay? Pwede nang gamitin as a collateral. Okay? Of course, there's a caveat. We need to be particular with the caveat that security interest may be created only when the grantor acquires the right in it or the power to encumber it. Okay? There are asset-specific rules provided by the law and also by its implementing rules and regulations. Okay, so some of the rules are found in section 3.05 in the implementing rules and regulation, section 8 of the law, then tangible assets commingled in a mass. This is again in the IRR, and so with accounts receivables. Okay? Again, dahil first time, parang paulit-ulit, first time siyang itatanong sa atin sa bar exams natin, siguro naman hindi tayo matatanong sa mga ganito. But of course, no? Of course, we need to be prepared. Hindi naman natin pwedeng sabihin, pag nakita natin yung tanong, ay bakit tinanong agad? Okay? So, for this purpose, we included in the notes this brief discussion on how to create security interest on yung mga nabanggit. Future property, commingled funds, tangible assets in a commingled in a mass, and accounts receivable. So that if matanong tayo, somehow we will be able to answer the question. But I hope na nakuha natin ang istorya. Okay? Yung future property. Okay? Future property, makaka-create tayo ng security interest only when the grantor acquires rights in it. Okay? Now, the rights to proceeds. A security interest in personal property shall extend to its identifiable or traceable proceeds. Okay? Here, naglagay na ng qualifier. Okay? For the proceeds to be part of the security interest, it has to be identifiable, it has to be traceable. Okay? Rights to commingled funds. Okay, commingled funds, nabanggit yung nakapag-cite tayo ng example kanina. So, right extends to the commingled money or funds, notwithstanding that the proceeds have ceased to be unidentifiable to the extent they remain traceable. Okay, so yung pera, yung proceeds na napagbentahan ng collateral, na i-deposito, na commingle, okay? So, hindi na siyempre magiging identifiable, right? Pero, to the extent that they remain traceable, okay, to the extent that they remain traceable, the security interest remains in the commingled fund. Okay? Tangible assets commingled in a mass. Okay, so ito pinag-usapan natin dito, hindi na pera, hindi na yung proceeds, but these are tangible assets that are commingled in a mass. For example, dahil kailangan ng mga ayuda, right? Yung bigas, yung mga sako-sakong bigas, wherein security interest was created, tapos na-commingle sa isang warehouse na punong-puno ng sako-sakong bigas. Okay, so that is the situation covered by this. And the law says security interest in a tangible asset tends to the mass. Okay? But of course, yung concept na familiar sa atin, yung pro rata. So the law says into the same proportion of the mass as the quantity of the encumbered asset bore to the quantity of the entire mass immediately after the co-mingling. Okay, so in short, hindi nawawala yung security interest just because these tangible assets have been commingled in a mass. Okay, so kapag nabigyan po tayo ng question dito, I hope na picture out po yung situation so that again, the purpose is for us to give an answer. Okay, an answer based sa batas. Now, accounts receivables. Okay? Interest on accounts receivable shall be effective, notwithstanding any agreement between the grantor and the account debtor or any secured creditor limiting in any way the grantor's right to create security interest. Okay? So, ano ibig sabihin nito? Let's say there is this account receivable and there's this agreement. There's this agreement between the grantor and the account debtor na hindi pwedeng gamitin ito to secure an obligation under PPSA. Ano sabi ng batas? Well, in case there is a security interest that is created on this account receivable, that security interest shall remain effective or shall be effective kahit meron pang agreement yung grantor tsaka yung account debtor. Okay, I think this is important because there are questions, there may be questions that may be formulated based on this provision of the law. Okay, now speaking of question, I think this is the last sample question that I prepared for this lecture. Again, given the time, it's time check, it's 10:38 and I'm supposed to end this lecture at 12 and I'm not even in naka 1/4. Siguro naka 1/4 na rin naman tayo ng lecture. Okay? So, sample question. A, obtained loan from B. The parties executed a security agreement with A's investment on a certain corporation. So what was used as a security? A's investment sa isang corporation. So security. The corporation was eventually dissolved. A received the value of his investment which was deposited to his bank account. Okay, I hope you see the picture. Okay, now A argues that B has no right over the fund since the security agreement is over his investment. And besides, the money is now commingled with his deposit account. Is A's contention correct? Okay, so kung magpo-formulate ng question base doon sa mga napag-usapan natin kanina, most likely ganito yung magiging picture niya. Okay? Ang argumento ni A, ang in-offer niyang security ay investment niya. Okay? Hindi yung proceeds. At kung sakali yung proceeds, na i-deposito ko na sa aking account. Okay? Sa aking deposit account. So, tapos na yung security interest ni B. Okay? So the suggested answer for this would be no, the contention is not correct since the security interest in personal property shall extend to its identifiable proceeds. Okay? Yung kaninang principle na napag-usapan po natin, yung first paragraph, a direct response, a direct answer to the question. Ang question dito is contention correct? No, it's not correct. And the reason why it is not correct is because the law, okay, says that the security interest in personal property shall extend to its identifiable. Okay? So yung paragraph 2 and paragraph 3, paragraph 2 is about the law, yung sinasabi ng batas, and then yung paragraph 3 is a discussion on the factual considerations. Okay? Paano tayo naka-arrive dun sa sagot natin sa paragraph 1. Okay? Alright. Now, continuation of security interest. Okay? Security interest shall continue in a collateral notwithstanding sale, lease, license, exchange, or other disposition of collateral. Now, that's the general rule. Some exceptions provided in section 21 or upon agreement by the parties. Okay, so again, I think the question will be on the general rule for the time being, and of course, di ba, yung security interest, it attaches on the property used as a security. So that kapag binenta yon, okay, pinarenta, pinalis, pina-exchange, then interest continues. Okay, so that's the principle behind this. Okay, so that's about creating security interest. The next topic is perfection. Okay, perfection of security interest, and the law says, section 11, security interest shall be perfected when, number 1, created. It was created, pero hindi lang doon matatapos. There must be the secured creditor, okay, has taken one of the actions in accordance with section 12. Okay? Before we discuss itong mga actions na ito, I think it's important for us to discuss first ano mangyayari kapag na-perfect, na-perfect yung security interest. Now, on perfection, the security interest becomes effective against third persons. Right? In short, creation, the agreement is between the grantor and the creditor, and that's valid. Okay, as long as na-comply yung formalities required, yung written, yung kasulatan nila. Okay, but yung third parties will not be affected without perfecting that. So that's the value. That's the importance of perfecting security interest. Okay, clear? Now, magiging tanong dito, for example, there's this A and B. They created a security interest and without perfecting it. Then there comes C, who claims interest on the collateral. And then, of course, alam natin magiging kwento, right? The question probably would be, what's better right? What's better right on the collateral? Is it B, the creditor, or C, a third party? Okay, the answer would lie on whether the security interest was perfected in accordance with law or not. Okay, because security interest becomes perfected. Okay. Now, means of perfection. Okay, means of perfection. We can provide a code here is familiar to all of us. RPC, right? Yung topic ni Dean Festin, yung kanyang expertise na criminal law. But in this particular case, we will use RPC to mean registration, possession, control. Okay, so security interest may be perfected by registration of a notice with the registry, possession, okay, possession of the collateral by the secured creditor. Okay, so when it's the secured creditor who has taken possession of the property, then the security interest is perfected and control. Okay, insofar as control, you will see here that it pertains to investment property and deposit account. Yeah. All right. So let's summarize. Huh? So let's summarize. So means of perfection. So you will see here in this matrix, registration, possession, control, and the collaterals, tangible assets, investment, deposit account. Okay. Tangible assets. Okay. It is perfected through registration, possession, but not control. Perfection of security interest on investment. Okay, it is perfected through registration and control, but not perfection. Bakit kaya? Well, kasi intangible. Right? Intangible. Well, siyempre, kung corporation, right, may certificate of stock. Okay? Pero that certificate of stock is merely the representation of yung investment on. Well, I think you know what I mean there. Now, deposit account. Same with an investment. It is perfected through registration and control, but not possession. Okay, but not possession. Okay. Now, let us discuss further the details of the rule. So, means of perfection in tangible assets, no? Tangible assets. This is based on Section 402 of the Implementing Rules and Regulation. It is perfected by either registration of a notice and possession, kahit constructive possession. Okay? Note, unregistered security interest is valid between the parties. I think we discussed this a while ago, right? Yung perfection in order to be effective against third parties. So even without perfection, valid yung agreement only as between the parties. Okay? Now, for intangible assets, okay? For intangible assets, it may be perfected by registration of a notice and conclusion of a control agreement. Okay, later we will discuss ano ba tong registration na to, ano ba tong control agreement na ito. Okay? For now, let's proceed to means of perfection in intermediate securities or deposit accounts. Okay? It may be perfected by either registration of a notice, creation of a security interest in favor of whom? In favor of the deposit-taking institution or intermediary, and conclusion of a control agreement. Okay? Means of perfection in electronic securities. Ito yung mga securities na walang certificate, uncertificated securities. Okay, yung uso ngayon. This is the reason why PPSA came about, right? Kung natatandaan niyo yung ating unang discussion, the purpose of PPSA para to modernize, and this is one of the reasons why there's a need to modernize the law in order to cover this electronic security. It may be perfected by either registration of a notice, execution of control agreement between the grantor and secured creditor, control to of in the books and the issuer. Okay? Para na ba tayong mag-French lesson ngayon? Right? I think makukuha naman natin yan. Right? Now, perfection of means of perfection in intermediate electronic securities. So, registration notice na control agreement. Again, yung table, yung matrix na pinakita kanina, na it's the summary of all that we have discussed before. This slides lang is in anticipation of a question na nagdetalye. But I think here, as of what presented, would be able to help us answer the means of perfection. Okay? Now, registration. Let me see for a Then, na rin, no? Medyo matagal na rin naman akong nagle-lecture, and I started teaching in 2001. No, it's almost 20 years na, okay? But this is the first time that I'm doing this, and hindi pala siya madali gawin, no? Hindi pala siya madali gawin. But katulad nga nung nasabi ko kanina, we all need to be prepared, and this, I think, is a precursor of the things to come. Okay, so while we are adjusting, I hope the learners and all of us are learners, makapag-adjust din tayo. Okay, makapag-adjust din tayo. Okay, now let's proceed. Registration. Okay, this is the reason why the Land Registration Authority would play an important role, because sila yung naatasan ng batas na mag-establish and mag-administer ng registry na yan. Okay, and part of the mandate is to provide an electronic means to search of notices. Later, malaman natin, I think, as students of law, right, ma-anticipate natin yung reason why search or searching of notice is important, okay? Is important. So, some basic rules. Public record, information contained in the registered notice shall be considered a public record. Okay, any person may search notices registered in the registry. Again, later, mababanggit natin yung importance ito, and yung electronic records shall be official records. Okay, now effectiveness of notice. So a notice shall be effective only at the time it is discoverable on the records. Okay, so how the court will eventually interpret this, because let's say you register your security interest date, but assuming that there are some procedures para maging discoverable, and it will happen after 3 days. Okay? So, kailan magiging effective? Is it at the time when you record it or at the time when it is discoverable? If you will look at the black letter of the law, then we would say that the law, the notice will become effective only 3 days after you register it. Okay, I think that's how it would go. Right? Now, notice shall be effective. Now, this pertains, letter B pertains to the duration. For the duration of the term indicated in the notice. Okay, so if it's for 1 year, then it's only effective for 1 year, unless there is a continuation of notice, and that continuation of notice is registered before the term lapses. The C says substantial compliance is enough. Okay, notice substantially complying with the requirements shall be effective, but there is again a caveat here if it is seriously misleading. Okay, misleading. Yeah. Now, possession. Okay, so yung possession here, the possession would be holding of a thing or enjoyment of a right. Okay, so this is possession. And perfection through possession, again, it applies to tangible assets, right? Kaya nga, di ba, it would be quite a thing, right? Possession of an intangible asset. Okay, so this is the reason why it's for tangible assets. And section 402 of the implementing rules and regulations says possession, whether actual or constructive, tangible asset, either by the secured creditor or a depositary acting for this creditor. Okay, so that's possession. And the implementing rule says provided that the debtor or the grantor cannot possess the collateral on behalf of the secured creditor for purposes of perfecting and maintaining the security interest over such collateral. Okay, so let's say A and B. A is the grantor, B is the creditor or the secured creditor in this particular case. Okay, supposing A made, let's say, a diamond ring as the collateral, and then A said to another person, palabasin natin that nauna yung security interest mo, okay? At kaya ko lang hawak ito because I hold it on your behalf. Okay? It be effective to be, give an example, well, this is our answer. The debtor or the grantor cannot possess the collateral on behalf of a secured creditor for purposes of perfecting and maintaining the security interest. Of course, the obvious reason for this is to avoid collusion, okay, to the detriment or to defraud secured creditor. Okay, it has also something to do with the priority interest or the determination of priority interest that we will discuss later. Diba? So this is another part that pwedeng maka-formulate ng question. Okay? Now, perfection through possession, tangible assets and the effect of perfection. Okay, here, if a security interest in a tangible asset is effective against third parties, a security interest in a mass, okay, again, in a mass to which the security interest extends, is effective against third parties without any further act. Okay, so without any further act, very important. Okay, now, perfection by control. Yan yung RPC, registration, possession, and now control. I think mas klaro yung concept ng possession right, tsaka yung registration. Here, there is this perfection by control, and this applies to a deposit account or investment property. Okay, so the creation of a security interest in favor of a deposit-taking institution or the intermediary. Okay, that's perfection by control. The conclusion of control agreement. And third, for an investment property that is electronic security not held with an intermediary, control is done through a notation of the security interest in the books maintained by the issuer. Okay, so malabo po ba? Yeah, right? We will try to clarify things. Now, as for number 1, creation of the security interest in favor of the deposit-taking institution or the intermediary. I think mas dadali kapag ma-identify natin, sino ba itong deposit-taking institution na to? So it refers to a bank, a non-stock savings and loan association, or a cooperative. So it's possible that magkaroon tayo ng meron tayong deposito sa bangko. Okay? So deposit account. Okay? And then we obtain a loan from the said bank. At anong gagamitin nating collateral? Yung ating account. Okay? At paano natin gagawin? Anong vehicle? Okay? Anong mode ngayon para maging security, maging collateral yung deposit account na yun? Control agreement. Okay? That is how to perfect a security interest on that deposit account. Okay, when we talk about deposit-taking institutions. Okay, now, what's a control agreement? Okay, so again, control agreement is a contract. It's an agreement. Okay, and because this is a contract, there are parties in this contract, and the parties to this contract would be the grantor and the secured creditor. Okay? And the subject is yung intangible asset. Okay? Now, ang undertaking is we will use this intangible asset to secure an obligation. Okay? To ensure that our obligation or the obligation of the debtor will be complied with. Normally, yung pagbayad. Okay? Pagbayad dun sa loan. Okay? Now, control agreement of intermediated securities. So, example of this, we invested, okay, in a certain corporation, okay. So the corporation is the issuer, right? Issuer of the stocks, issuer of a bond, probably, okay. And then there's this intermediary that facilitates yung pag-acquire ng public doon sa mga bonds at securities na yan. Yun yung intermediary. Okay? So, control agreement is among the issuer or the intermediary, the grantor, and the secured creditor. So, in this particular case, I want you to imagine there are 3 parties here. Number 1, yung debtor, grantor, and then yung issuer or intermediary, as the case may be, and then the third party is the secured creditor. So, tatlo. Okay? So, ano ang control agreement? There is this agreement, okay, to which the issuer or the intermediary agrees to follow the instructions not from the grantor or the debtor, but instructions from the secured creditor with respect to the security. Okay? At ito, I think, yung pinaka-importante, without further consent from the grantor. Again, without the further consent from the grantor. Because that's what control is all about. Who controls now? Who controls now the security? It's no longer the grantor, right? it is now the secured creditor that controls the investment or the bond or the security. And this secured creditor may give instruction to the issuer or to the intermediary without further consent from the grantor. Okay, and that perfects the security interest on this intermediated. Okay, now deposit account, same principle. Okay, so there are three parties: the depositor, okay, depositor, the deposit taking institution, okay. This depositor has deposit on this deposit taking institution, and the depositor would use this deposit account to secure his or her obligation to a secured creditor, okay, to a secured creditor, okay. Now, control agreement happens when there is an agreement sa mga parties na ito that the deposit-taking institution would follow the instruction from the secured creditor and no longer from your grantor, okay? Without the further consent from the grantor. That's how control agreement is done in a deposit account. Okay? Commodity contracts. Ito yung mga nakikita natin sa mga sini-trade. Okay? Sini-trade. So, control agreement is among the grantor, creditor, and the intermediary, according to which the commodity intermediary will apply any value distributed on account of commodity contract, again, as directed by the secured creditor without further consent by the commodity customer or grantor. So you would see the pattern, right? Kaya siya control agreement. It's now the security, the secured creditor that actually exercise control on the on commodity contracts, on the deposit account, or in the intermediated securities. Okay. Now that's control. Now, time check, it's 11:07 and I'm not even halfway of the lecture. Thank goodness. But anyway, now the full notes, the full text of the lecture, you can have it, you can download it in the link provided by Rex Bookstore. Again, thank you, Rex Bookstore. And I hope you find the notes useful. Okay, now priority rules. Okay. Priority rules. Wait a minute. All right. All right, priority rules. The situation here is, we said earlier that let's say this is the collateral, okay? And the grantor, the debtor, use this collateral to secure several obligations, okay? But these priority rules establish the rule, sino mauuna? Who's better, right? Let's say secured creditor 1 versus secured creditor 2, okay? Sino ang, who has better right? Okay. Now, the general rules provided in section 17, the determination is according to time of registration. Okay, so kung the perfect, let's say creditor A, creditor B, creditor C, all of them have the same security interest on the same collateral, but creditor A has the earliest registration of notice. Okay, so the obvious answer would be see, creditor A will have the better right over creditor B and C. So that's the principle in section 17. Okay, I think that's clear, right? Now, but this is just a general rule. There are asset-specific rules, okay, as discussed in the succeeding sections. Section 18, deposit account. Okay? Now, ito ng deposit-taking institution. Again, yung bangko, yung savings and loan, let's say, for simpler discussion, yung bangko. Okay? So, the debtor, okay, obtain a loan from the bank, and the debtor use the deposit account on deposit account dun sa bangko na yon as his security. Okay? But this depositor, okay, this grantor, also used the same deposit account to secure his obligation sa ibang secured creditor. And that security interest was perfected by other methods. Okay? Possession, registration. Okay, assuming, yeah. Okay? Now, who was better right? Section 18 says, it is the deposit-taking institution that has better right, not the earlier registration. So kahit sabihin ni security interest perfected by other method, hindi, mas nauna ako. Okay? The rule is specific in this particular case. The law says that yung deposit-taking institution will have a priority interest over security interest perfected by other methods. Okay, so that's how you should read this illustration. Okay, yung banda dito, ang mas may priority. Okay, now, deposit account or investment property. Okay, now this particular rule applies not only on a deposit, not only to a deposit account, also it applies to an investment property. Okay, so security interest perfected by control agreement will have priority over security interest perfected by other methods. Okay, except deposit-taking institution. Yung unang rule kanina. Okay? So in short, kung ang labanan ay deposit-taking institution versus secured creditor na na-perfect niya, other means, mananalo si deposit-taking institution. Pero, okay, as between a secured creditor by control agreement versus a secured creditor who perfected the security interest by other method, mananalo pa rin si control agreement. Okay, clear? I hope that that's clear. Okay, except deposit-taking institution. Okay, now assuming, okay, assuming ang labanan naman ay secured creditor who both perfected their security interest by means of control agreement. Okay, so secured creditor A versus secured creditor B who both perfected it by a control agreement. Sino ang mananalo? The illustration says, section 18 actually says, kung sino ang mas earlier yung control agreement. That secured creditor will have priority. Okay? Sino ang mas nauna? Okay. Now, but, right? Para naman sa mga ginamit na collateral is an intangible, a security, but nag-issue ng certificate. Okay, the issuer issued a certificate, a security certificate. Okay, section 18 says the secured creditor with security interest perfected by possession, okay, will have preference over security interest perfected by registration. Okay, clear? So, stopping certificate pa rin. Now, electronic securities, okay, not held with an intermediary. Okay? So, ang nag-issue ng security na to, diretso dun sa issuer. Walang in-between, walang intermediary. Okay? Now, the secured creditor who perfected his security interest by notation. Saan yung notation? Doon sa books maintained for the purpose by the issuer will have priority over those secured creditor who perfected their security interest by any other method. Okay? Clear? Klaro naman. I hope it's clear, right? So, I think moving forward, the question on this particular topic, pagbabanggain yung different secured creditor, okay? Ang tanong, who has better right, who has priority, okay? And in order for us to answer that, alam natin yung general rule, Section 17, and then all the specific rules under Section 18, okay? So, sa umpisa lang siya nakakalito, but we will get the hang of it kapag nagpapamiliarize tayo sa mga rules. Okay? Now, electronic securities not held with an intermediary. Laban na naman, control agreement versus registration. Okay? Section 18 says, sino ang naka-perfect by means of control agreement will have priority, okay, over registration. Okay? Electronic securities not held with an intermediary. Usaping control versus control. Okay? Ito, madali na yung rule, right? Sino ang mas may earlier control agreement will have priority kung ang kalaban ay control agreement. Okay? But again, control agreement versus registration. Control agreement, not the date. Okay? Control agreement versus control agreement, the earlier control agreement. Now, negotiable documents, right? Instrument and negotiable document. And this is not limited only to negotiable instrument. And I think many are happy that negotiable instruments law, hindi siya na-include sa 2020 bar exams, right? Okay, so, but somehow, nagkaroon din siya ng discussion dito. Okay, so security interest perfected by possession on that document will have priority over security interest perfected by registration. Okay, kung natatandaan natin yung concept ng negotiable instruments, right? Diba? There is delivery. Okay? Yung pag-endorse ng document ng negotiable instrument, delivery is necessary. Okay, so, and that delivery will give you possession. Now, goods in the ordinary course of business. Let's say, for example, you own a store and you, yung stock in trade, yung stock mo dun sa tindahan, yun ang ginamit nating pang secure ng ating obligation. Okay, so Section 20 says a person who provides services or materials was possession will have priority until payment thereof versus secured creditor. Okay, so possession pa rin because rightly so, these are tangible assets. Okay, now livestock. Okay, ito yung mga livestock. So, Section 24 says, may priority yung secured creditor na nagpautang sa grantor para maka-obtain si grantor ng food and medicine sa kanyang livestock. Okay? Siya ang may priority dun sa livestock na yon. Okay? Now, sa isang banda, ang sabi, this security interest will enable the grantor obtain food or medicine will have priority over other secured creditors except if written notice is given before grantor receives food or medicine. Okay, so anong ibig sabihin nito? Let's say, nagpautang tayo sa itong negosyo, livestock, tapos nakababalita tayo that there is this this pandemic na para sa mga notice sa mga assume magkaroon is priority dito Hi. I was told that there stopped yung video. Yeah, probably because of well, not probably because this is due to technical difficulties. Okay, so I hope you can now hear me. So let's resume. I was discussing about priority interest on livestock. I think the concept is kung ang nagpautang to enable the grantor to obtain food or medicine, then that creditor will have priority over other creditor, except if those other creditor be able to give notice before the grantor receives the food and medicine. So, dalawang qualifier, right? Dapat may written notice, but that written notice should be given before nakuha ng grantor yung food and medicine. No? If magkakaroon ng actual case dito, just imagine yung dami nilang kailangan patunayan. Okay? Now, fixtures, accessions, and commingled goods. Okay, Section 25, perfected security interest in a movable property which has become a fixture. Okay, so let's say, ginamit nating security, nating collateral, movable, pero i-finix, okay, sa isang immovable property. Okay, the law says that security interest, the security interest continue provided both property can be isip akong joke, kaya lang time natin gagawin, ha? And okay, so secured interest may enforce security interest or through an extrajudicial. Okay, so yung usapin natin, I hope na ba yung principle. Hindi pa rin pwede ang automatic approbation. There should be a process, be it judicial or extrajudicial. And this process would include sale, either public or private. Okay? Now, in conformity with the Constitution, the law says that any judicial investment shall be governed by the rules promulgated by the Supreme Court. Okay, the last time I checked, wala pang rules dito, but we can expect that rules will be issued by the Supreme Court. Okay, now what is important according to law is yung repossession, and not just repossession. The law says expedited, pinamadaling repossession. Okay, and you, I think you will find this interesting. The secured creditor may take possession of the collateral without judicial process if the security agreement so stipulates. Okay, provided that the possession can be taken without breach of peace. Okay, so ito pa rin yung principle that you cannot take the matter into your own in your own hands, right? So kapag magkakaroon ng breach of peace, then hindi pwede ang repossession. And the definition of breach of peace in this context include entering private residence of the grantor without permission, resorting to physical violence or intimidation, or being accompanied by a law enforcement officer when taking possession or confronting the grantor. Okay, so these are breach of peace. At kung mangyayari ito, then hindi pwedeng repossession without judicial process. Okay, because you will violate yung prinsipyo nga na don't take matters into your own hands. Okay, expedited repossession of the collateral without judicial process. Again, it has something to do with a fixture. Okay, this fixture that is affixed in an immovable, pwede. Okay, again, walang breach of peace, and the secured creditor has this obligation to exercise due care in removing the fixture. Possession of the collateral without with judicial process. Okay, if the on second sa rules. Right? Okay, let's say or check if our um, all right. Hi, I'm back. Naku, pasensya na kayo. There is a connection issue. Okay? So I hope you're still there. And hindi ako nagsasalitang mag-isa dito. Well, anyway, the topic that I was discussing, I was told, expedited repossession of collateral with judicial process. So basically, we said earlier that there is a rule that the Supreme Court would issue, and the law mandated them, again, in accordance with the Constitution. For lack of time, we will no longer discuss this in detail by law lecture. Let's right after that